Am I audible? Hello.
Yes, Vicky, you're audible.
Yes, Vignesh, you are audible.
Okay, we will start. A very good evening to one of present here. This is Vignesh Kannan, the Marketing and Promotion Head of Law Addicts. First and foremost, I welcome you all to a webinar on state and center under Indian Constitution law. And here we have a key speaker, Mr. Chandrasekhar Bharati. I'm here to deliver a brief introduction on Law Addicts and its objectives. Law Addicts is a student-formed organization which conducts various webinars and workshops, moot court competition, and other events with a nominal fee in order to achieve its long-term objective of providing scholarship to law aspirants who find difficulty in participating in various competitions solely because of financial situations. Hereby, I thank you all for being a part of a webinar and help us in achieving our motto. With this, I would like to call upon our secretary, Ms. Yuvashree, to give the key speaker introduction. Yuvashree, you may carry on. Thank you.
Thank you, Vignesh. A very good evening to the participants. Before starting our webinar, I am here to introduce our esteemed speaker for the event. We have our speaker, Advocate Chandrasekhar Bharati. Sir is a graduate from Shastra University of Law and is currently working in the chambers of Venkatraman, the Additional Solicitor General of India. During his college days, Sir has participated in numerous moot court competitions, the Asia Pacific Moot at Singapore, where his team has ranked the third place. And Sir has also won in the Ramamani Taxation Moot Court competition and a plethora of other moot court competitions. Apart from this, Sir has also published numerous articles in various journals. Do or do not, there is no try. He follows this principle in life, and this is the reason behind his success so far. With this, I welcome you, sir, on behalf of the entire team of Law Addicts for our webinar on the state and center under Indian constitutional law. Welcome, sir.
Thank you so much, Yuvashree. Thank you so much. Thank you to the entire team of Law Addicts, and in particular Sonu Mehta today for this wonderful opportunity to be here and to giving me an opportunity to present today on this topic. I would also like to thank Honorable Justice Subramaniam Prasad for his webinar with the Lex series on this very subject that helped me form my basic structure and outline for today's presentation. I have referred to around 30 to 35 articles and I have collated the data, and I will be presenting everything that's available in the web in a structured format today. So everything I speak today is traceable to some source of online in the web, and it's just collation of data. The topic I have chosen today is the relation between the state and the center under the Constitution of India. And we will be discussing today this topic through the three organs of the government, which is the legislature, the executive, and the judiciary. Now, with this in mind, we can proceed forward to the first aspect of discussion, which is how the state and the center are related concerning the legislature. The first organ that we take is the legislature. Now, let's understand a few basic concepts, a few basic articles, so that we have the basics set straight in our minds before we proceed. Article 245 of the Constitution allows the Parliament to enact laws for the whole of India or any part thereof. Article 245 again allows the states to form laws for the whole state or any part thereof. Now, there are three lists under Schedule 7 of the Constitution. Now, these three lists are called as the Union List, the State List, and the Concurrent List. Now, under Article 246 of the Constitution, Parliament can make laws under the Union List and the Concurrent List. States can make laws under the State List and the Concurrent List. And Parliament cannot make laws for the entries under the State List. And similarly, states cannot make laws for the entries under the Union List. Now, with this in mind, we will proceed to discuss today how and under what scenarios do the conflicts arise and what are the mechanisms that the courts use to resolve such conflicts. This will be the first part of the presentation. Now, before we proceed to the conflict zone, it is to be kept in mind that the court always has to try and uphold the legislation first, meaning they should always try and find a way to resolve the conflict before striking down a law as bad. And in fact, Justice Markandeya Kajju, in one of his judgments, he has even used the Mimamsa principle of interpretation that helped him find out a harmonious construction that helped two statutes live and operate at the same time. So the first objective for a court is to always reconcile. Now, keeping this objective in mind, we will proceed to discuss now 3 areas of conflict that commonly arises. Now, what is the first area? There are 2 central enactments and there is a conflict between both these 2 central enactments. In those cases, how does the court proceed and approach that particular issue? Now, the court uses 2 mechanisms here to resolve such conflicts. The first method that is used by the court is this special legislation will always prevail over the general legislation. Now we look at this. So the scheme of today's discussion will be representing the approach and understanding the approach through judicial precedents. And I have ensured that the case laws that I take relates back to the 1950s and 60s because that is when all these concepts were evolved. And it is always fun to understand how it came, the initial source of such concepts. So let's understand this special over general will prevail through the judgment of Sharad Babu versus Government of NCT Delhi. Now, what had happened in this case was the accused was charged under 292 IPC, 294 IPC, and 67 of the Information Technology Act. Now, 292 IPC states that it will be a punishable offense to publish something that is obscene. 67 IT Act states that it will be punishable to publish something obscene through an electronic forum. Now, the charge against the accused in this case was that he published obscene materials in an electronic forum. Now, the accused goes to the High Court first, requests the High Court to drop the charges against him. The High Court says that the charges against Section 67 of the IT Act is dropped and reminds the matter back to the trial court to proceed trial under 292 IPC. Then the accused goes on appeal to the Supreme Court. Now, the question of law before the Supreme Court was, when charges under 67 IT Act is dropped, can the trial under 292 IPC continue? The Supreme Court said, no, it is not possible for one simple reason, that any offense relating to publishing obscene materials on an electronic forum, a special legislation called the Information Technology Act is brought by the Parliament, and Section 67 covers that. The minute Section 67, the charge against under that provision is discharged by the High Court, 292 IPC cannot prevail. So this is one classic example of a special legislation prevailing over a general legislation. Now, there was also another very interesting case of KSL Industries versus Arihant Threads. What happened here was there were 2 special legislations. So the court took a very unique approach to understand and resolve the conflict. Now, what were those 2 legislations in this case? There was the SICA Act. SICA Act is the Sikh Industrial Special Companies Act, and there was the RDDB Act. RDDB Act is the Recovery of Debts Due to Banks and Financial Institutions Act. Now, both of these are central enactments, and both of these are special enactments. Special why? Because the first SICA relates to Sikh companies, and the RDDB is in particular to recovery mechanisms available to banks and financial institutions. So both are very, very special enactments. Now, under 22 of the SICA Act, recovery proceedings cannot be initiated against a Sikh company if certain criteria are being met. Now, on the contrary, 34 of RDDB says that no matter what law prevails in the country, 34 will be in operation. Therefore, despite 22 SICA, RDDB will prevail is what RDDB states. Now, this was a conflict. The Supreme Court adopted a very unique approach here. They said it will be futile to proceed for recovery against the SIG company. Therefore, an initial chance has to be given to the SIG company to recuperate, to get back on its legs. And therefore, after that, the recovery proceedings under RDDB can take place. So therefore, the point that is to be understood is when there are two special legislations, the court can always look at the intention behind both the legislations, and take a very reasonable call as to what will help in those situations to make sure that both the laws are running and active in the country. Now, the first mechanism that is adopted is special over general. The second mechanism that will be adopted by the court will be the latter enactment will always prevail over the former enactment. And this can be understood by a very, very interesting example. Now, under the Maintenance and Welfare of Parents and Senior Citizens Act, this was brought by the Parliament in the year 2007 to, it was a beneficial legislation for the welfare of senior citizens. And they constituted a tribunal under this act. And under this, it was mainly to protect the property and the gifts that were being done by parents and senior citizens. Now, Section 17 of this act states that no legal representation will be allowed. That is, an advocate will not be allowed to represent a senior citizen before this tribunal. Now, on the contrary, there exists the Advocate Act 1961. Section 30 of the Advocate Act says every advocate has the right to appear before all courts, including the Supreme Court, and it also includes a tribunal. Therefore, as a matter of right, an advocate can make a representation under Section 30 Advocates Act. Now, the interesting question and the common understanding is Advocates Act came in 1961. The Welfare Act came in 2007. The 2007 Act, being a latter act, will obviously prevail. Not so. Why? Because even though Section 30 was part of the initial Advocates Act 1961, it was brought into force only in the year of 2015. Therefore, once it came into effect in 2015, since that is being a latter act, in the case of Paramjit Saroya, Justice Sanjay Kishan Kaul, when he was serving as a judge before in the Punjab High Court, he held this judgment that even though Section 17 bars legal representation, despite after Section 30 came into force in 2015, that provision will prevail. And now in state of Punjab, legal representation can be allowed before the tribunal. This was the holding. So this is another example of the latter prevailing over the former. Now, with these two approaches in mind, let's move on to the next zone of conflict, which is when there is a conflict between the central list and the state list. Now, the approach that the courts adopt will be the concept of pith and substance, which is very, very important to understand. So what is pith and substance? I will read out from a Supreme Court judgment explaining this concept. It makes the understanding even better. It says, in the case of ITC Limited versus Agricultural Product Market, the court holds the concept of pith and substance to be as follows. Although Parliament cannot legislate on any of the entries in the state list, it may do so incidentally by legislating within the entries under the union list. Conversely, the state legislatures may encroach on the union list, while such an encroachment is merely ancillary to an exercise of power intrinsically under the state list. The fact of encroachment does not affect the bias of the Constitution of law, even as regards the area of encroachment. Now, in simple words, they say that pith and substance means if you're legislating under the union list, if the substance of the act that you bring in is predominantly under the union list, it will hold good even if it incidentally encroaches upon the other lists, such as the state list. Now, this is the doctrine of pith and substance. Now, let's understand this concept through two case laws. The first one is a very controversial and a very interesting case, which is Ismail Farooqi versus Union of India, a 1993 Supreme Court judgment. Now, this was during the times of Babri Masjid Ram Janmabhoomi dispute at its peak. Now, what happened was the center, the ruling party at that time brought the acquisition of land at Ayodhya Act 1993. Now, the purpose of this act was to acquire certain lands in Ayodhya and to build a mosque and a temple so that this conflict can be put to rest even back in 1993. Now, what happened? There was a case filed against the act, calling it unconstitutional, mainly for one ground, which is acquisition falls under list 3, which is the concurrent list where both the states and center can make law. However, since this legislation was brought mainly to settle public order, and public order falling under list 2 is completely under the state's control, the parliament cannot pass such a law encroaching into the state list. This was the concept. Now, the court said, after looking into the Ayodhya Act 1993, they say that it mainly dealt with acquiring lands in the state of UP at Ayodhya, and therefore it fell predominantly under in pith and substance under the concurrent list of the entry called acquisition of land, even though it encroaches upon the state list called public order, an entry called public order. The Ayodhya Act will prevail. So there was no problem. And when we discuss pith and substance, the Prafulla Kumar versus Bank of Commerce case cannot not be discussed. Now, what happened in this case again is the then state of Bombay passed a legislation called the Money Lenders Act. Now, money lending is a subject under the state list, falling under it's one of the entries under list 2. Now, this act also deals some portions of promissory notes. Now, promissory notes is a subject under list 1. So it was challenged before the court that under the pretext of passing a law under the list 2, they are encroaching under the entries in list 1. The court said in pith and substance, it was Money Lenders Act and predominantly fell within the competence of the state list. The limited encroachment into promissory notes should be neglected and will not be a problem for holding the act as constitutional. Now, so a quick recap: when there is a conflict between two central enactments, latter over formal, special over general will be the two mechanisms used by the court. Now, when there is a conflict between the center and the state, harmonious constructions, pith and substance will be followed. Now, let's proceed to the final angle with respect to this organ of the government, the third zone of conflict, which is the aspect of repugnancy. Now, repugnancy occurs only when both the state and the center are passing laws together on a particular subject. And that can happen under only one list, which is the concurrent list. Now, under Article 254 states that whenever there is a law that is passed both by the parliament and the state, and the state laws are repugnant to the parliament's law, to that portion of repugnancy, the state law becomes invalid. It becomes void. Now, very, very interesting point is, I'll just come to that in a minute. Let's understand repugnancy through a case law first, which is in the case of Zaver Bhai versus State of Bombay. What had happened was there existed the Essential Supplies Act. And under this act, if you certain offenses were prescribed and punishments were followed for such offenses if being committed. Now, what happened? This was a central enactment. Now, State of Bombay also had power under the act to enhance the punishment, so they did that. After State of Bombay enhancing the punishment, the Parliament amended the Essential Supplies Act. Now, after the amendment, Bombay's enhancement of punishment became repugnant. So therefore, to that extent of repugnancy, it was considered to be void and the Central Act prevailed over the state. Now, there's this case called Mar Aparam Kuri, 5 judges of the Honorable Supreme Court. They hold that the law becomes repugnant the minute Parliament passes the law. That is, when the President gives his assent, that's when the law comes into force. And the repugnancy starts from the minute the President gives his assent. Justice Subramaniam Prasad, in his webinar with Lex, raises a very, very important academic argument. What happens to law that has received the assent of the President but has not been brought into force, then in those areas, how will the aspect of repugnancy be played? That's a very academic argument, but if someone has the answer to it, I would be very interested to know during the end of the session, because in all honesty, I wasn't able to find a very convincing answer for that. Now, with so the relationship qua the legislature, we can complete the discussion on that here. Now, I'd like to proceed to the next aspect: how the state and the center are related to each other via the judiciary. Now, there's only one article in light of which I will be discussing this concept, which is Article 131 of the Constitution. Article 131 confers the Supreme Court original jurisdiction to entertain certain cases. Now, who can approach under 131 is the first aspect that I would like to discuss. 131 states, if the states want to proceed against the union, or the union want to proceed against the states, or if the states want to proceed against other states, they can approach the Supreme Court. Now, under what can they approach the Supreme Court? Article 131 has the answer to that also. Article 131 says that it can be a question of law or a question of fact falling out of a legal right of that particular state or union. Now, when I say legal right, one thing has to be understood, that is, it is the legal right of the state and not the legal right of the political party ruling in that state. Therefore, it is the right of the state of Tamil Nadu, right of the state of Karnataka. That matters when an approach under Article 131 is made. Now, instead of discussing cases under 131 where there have been successful and unsuccessful attempts, we will try and discuss two major issues that arise under 131. The first aspect came up in Ajay Hazia versus Khalid Mujib. An important question of law was raised, which is Article 12 of the Constitution states that the meaning of the word state includes the government, the legislature, all municipal and local bodies, and through judicial interpretation, several other independent private bodies have also been declared as a state. Now, if the states can approach under 131, will the same meaning the state has under Article 12 also apply to Article 131? Was the question of law before the Supreme Court. In Ajay Hazia, the court holds that the meaning state has under Article 12 will not be the same meaning under 131. Why? Because this is a very, very special original jurisdiction that is conferred on the Supreme Court, and it is only that particular state and not its representative or other bodies that can approach. Now, with this being settled, we'll move on to the next important conflict, which is the legal right that we were discussing. In state of Karnataka versus Union of India, Justice Bhagavati makes a very important holding that there can exist a question of fact, there can exist a question of law, but unless it is falling out of legal right, nobody can make an approach under 131 of the Constitution. So keep this in mind. Then I have a very interesting question to ask. In light of this, can the states approach the Supreme Court and challenge central enactments? Because this is very pertinent to the current the scenario that we live in, because state of Kerala, I think, was the first state that approached the Supreme Court under 131 to challenge the CAA 2009 that was passed. Now, could the state of Kerala have done it? Because under 131, it says it has to flow from a legal right. Now, does the state of Kerala does it have a legal right to go under 131? Now, there are two conflicting decisions of the Supreme Court in this regard. In state of MP versus Union of India, the court holds that the central enactments cannot be questioned under Article 131. But later, in 2012, in Bihar versus Jharkhand, Justice Chalameshwar and Justice Bobde hold that states can definitely question this under Article 131. That is, the state does have the right to question central enactments and its validity before the Supreme Court under Article 131. But unfortunately, what had happened was the earlier decision was also a two-bench. The latter decision in 2012 was also a two-bench, so that means that the bench could not have overruled it. Therefore, what the 2012 bench did was they had referred it to a larger bench, and it's currently under consideration. The judgment is not out on this regard. So that question of law is still open before the Supreme Court. Now we will proceed to the final aspect of today's presentation, which is discussing the relationship between the center and state qua the executive angle. Now, there's a separate chapter under the Constitution of India that deals with the administrative relation, etc., etc. But I will not be delving too much into those angles. I'll just give out certain basic articles that are important, and I will discuss one important issue that happened last year on August 5th as to how the president moved under Article 370, exercised his powers and applied the Indian Constitution to the whole of Jammu and Kashmir. Now, to the basics, Article 52 says that there shall be a president of India. Article 53 says the president of India shall be the executive head, and all executive actions shall be done through him or through subordinate persons under him. Now, what is important is Article 73. It states that wherever the parliament has the power to pass laws, the executive power of the president also extends to those areas. Now, under 256 of the Constitution, if the states are not enforcing the laws passed by the parliament, parliament can issue directions or on that matter of enforcing or on any other matter to the states to make them enforce these laws or enforce any other directions given by the parliament to the states through the executive. Now, with these basics in mind, let's understand how the President of India proceeded under Article 370 and extended the whole Constitution to J&K. Now, Article 370, what is important is three aspects. The first one is Article 370 1D. 1D states that the President may, by order, extend the Constitution of India with exceptions and modifications as he deems fit to the state of Jammu and Kashmir. There are two conditions prescribed in it. If the conditions are this: if it's matters falling in the instrument of accession, then there has to be a consultation with the government of J&K before passing such an order. If it's matters falling outside the instrument of accession, then a concurrence is required from the government of J&K. Now, clause 2 of Article 370 states, wherever concurrence is required under 370, if it has to be given prior to the Constituent Assembly of J&K is formed, then it shall be placed before that Constituent Assembly and they will give the permission instead of the government of J&K. Now, more than these two articles, what is most important is Article 370 Clause 3. 370 Clause 3 states that the President may, by public notification, state that this particular Article 370 will stop operating with exceptions and modifications as he deems fit. But there's only one trouble in it, which is it has a proviso. The proviso stated that the Constituent Assembly of J&K, which were enforced, which were given the duty to frame the Constitution of Jammu and Kashmir, they had to give this recommendation to the President of India to proceed and make 370 inoperative. Now, unfortunately, what happened was the Constituent Assembly of J&K stopped being in sitting several years back. Now, because of that, in 2018, the Honorable Supreme Court of India also holds that because of that angle, Article 370 has attained a state of permanency. Now, despite that, how did the President go about it? Now, let's revisit 1D again just for a second. 1D says the Constitution can extend to J&K with exceptions and modifications as the President deems fit. Now, what were the modifications that the president did to achieve the end result, that is making 370 inoperative? The first change that he brought about was he changed the words Constituent Assembly of J&K to mean as the Legislative Assembly of J&K. Now, whether this is right or wrong is something that the Supreme Court has to hold. But there seems to be some rationale behind the decision for this particular reason, which is with respect to the state of J&K alone, Constituent Assembly and Legislative Assembly can mean the same for this reason. Why? Because unlike India, India's Constituent Assembly was filled with members who were selected. On the contrary, Constituent Assembly of J&K, when it was formed, was members who were elected through an election. So they actually performed the role of a legislative in J&K. Therefore, there seems to be some rationale in calling the Constituent Assembly as the Legislative Assembly. Now, the first modification that he did was this. Now, as a result of this, what followed? There was no Legislative Assembly that was in sitting at J&K. Now, what followed after that? The president's rule was imposed in J&K. Now, when the president's rule is imposed, it comes under the union's control. That particular state comes under the union's control. And it is the union that is responsible for taking all legislative measures with respect to that particular state. And for passing an order under 373 to make 370 inoperative, the concurrence of the Legislative Assembly is required as per the new modification, which the government was capable of doing in light of the modification. Therefore, 370 was removed from completely, and the temporary status given to J&K was abrogated. Now, with this, I would end my presentation. We have a lot of time in hand. So I would take up questions, or I would also indulge in discussions, and also I'm interested to learn if anyone has any value addition to add to this discussion.
Thank you, sir. In a minute, Pravesh will take over the session and moderate the questions.
Sure.
Good evening, sir.
Hello.
Yeah, we can start in a minute, the questions.
Sure, please.
So I believe there's one person who's raised his hand, Mr. Anirudh Kumar. So sir, I'll unmute you and you can put forth the question.
Okay, sir, can you hear me?
Yes, Anirudh, yeah, hi.
Okay, sir, just a small clarification with regards to Article 12 and 131 which you gave.
Yes.
So, with regards to what you said, what I personally feel is that shouldn't Article 12 take the area of precedence, because it forms the fundamental rights, whereas Article 131 is mere constitutional rights conferred upon the state?
See, if you understand the motive and the objective behind 131, I think that will answer your question. I'll take a minute and answer yours. See, 131 is for specific grievances that the state governments or the union governments have against other governments in the country. Now, let's take a classic example of river disputes in the country. All right. So initially, before the Interstate River Water Disputes Act was brought and the jurisdiction of the Supreme Court was completely taken away, all matters that were involving river disputes came before the Supreme Court. Now, that I'm just quoting river disputes because it is the most common disputes between two governments in the country, even in 2020, dating back from 1950. Now, if you understand this, I will also go to the second limb of my explanation to say what will happen if everybody who is a state is allowed to come under 131. Then it will not make any difference under Article 32 and Article 131. Under Article 32, anybody can approach for violation of fundamental rights. If the same jurisdiction is expanded under Article 131, it defeats the exclusivity that is given to states and the governments under union and the state governments. Therefore, I think there's a huge difference as to why Article 12 will not, when the state under 12 will not have the same meaning under 131.
Okay, sir. Can I ask another question?
Please.
Okay, sir. In the recent, not recent, very sorry, in a petition filed by Shah Fasil in the year 2019 with regards to the application of Article 370, so therein the counsel who represented Shah Fasil gave a very neat argument with regards to the role of literal construction, wherein it stated that because of 371C of the Constitution stipulates that notwithstanding anything in this Constitution, the provision of Article 1 and of this article shall apply in relation to that state. And Article continuing, Article 371D stipulates that such of the other provisions of this Constitution shall apply in relation to that state, subject to exceptions and modification as the President may specify. So it is therefore evident that Article 371D provides constitutional authority to the President by order to amend or bring any new applications to 370 to the state of Kashmir.
You're right.
Except for Article 1 and 370 itself. So how can the President use such a drastic?
No. May I ask you why the President cannot make modifications for 370? But in fact, I think he made a change to Article 367 of the Constitution, which is outside 370. Because 367 states that the General Clauses Act will apply for the interpretation of this Constitution. And I think the 2019 presidential order that was passed, he made changes and modifications to Article 367. Therefore, I think he did not modify 370. Therefore, I think, going by your line of argument also, an amendment was made to 367 while extending it to JNK.
Okay, sir. Just a small follow-up. Very sorry. So
Sure,
okay.
please.
So keeping what you just said in mind, I can bring the argument which was stated, which I can bring the judgment of S.R. Bommai into this, right? Because in that case, Supreme Court held that the government cannot be equated with the governor in matters which involves the permanent restructuring of the state.
I'm losing you, Anirudh. Can you repeat? I'm sorry. Hello.
Okay.
Yeah.
Can you hear me, sir?
Yeah. Now I'm able to hear you. Okay,
so I can bring my argument from the judgment of S.R. Bommai, wherein the Supreme Court said that the government cannot be equated with the governor with regards to matters involving the permanent restructuring of the state itself, right? So, in this case, the Legislative Assembly was not functioning at that time. So, how can the President herein take in the advice of the governor, who is a mere representative of the central government itself, to the state at that point?
Correct. So, I would again refer to the scheme of the Constitution, which is whenever there is President's rule, the Union is responsible for that particular area where President's rule is imposed. So, I understand where this is coming from, because when there is no Legislative Assembly, getting a concurrence from the Union representative is mere going behind the back is what is the approach common. But I think if it can be traced to some source of law, and if there is legislative backing or legal backing to it, that is again subject to interpretation by the Supreme Court. But to answer your question, if there is President's rule, I think Union takes over all actions in that particular area where there is President's rule. In light of that, I think if this is done, it cannot be questioned that particular angle is my honest and humble opinion. I may be completely wrong.
Okay, sir. Thank you, sir. Thank you so much.
Thank you.
That was a detailed answer, sir. Next question, we have Mr. Abhishek Chetia.
Can you
At the
unmute
outset,
him?
yes, sir, we can unmute him. Can the technical team unmute Mr. Abhishek Chetia?
Sorry to interrupt, but I believe Mr. Setia will not be able to unmute himself right now because of some technical glitch.
Okay. All right. Sure. So I'll just read his question. With regard to Article 370 and the explanation given in the presentation, I wanted to ask what is your opinion on the same with respect to doctrine of colorable legislation. Okay, very, very interesting question. So I would answer it in two limbs. Now let's first understand what is colorable legislation so that everybody understands this particular aspect Mr. Sethi has raised today. Colorable legislation is nothing but the opposite of pith and substance. Now in substance, if you see a particular legislation, if it predominantly falls within the legislature's list, that is, the competence is traceable to a particular list, but in substance it encroaches the other legislature's entry, then due to colorable legislation, it will be struck down. The core principle can be summed in one line, which is what you cannot do directly, you cannot do indirectly. That is the principle of colorable legislation. Now let's apply this to Article 370. I would approach it this way. Now, as the title of 370 says, the provision is temporary. Now, when the provision is temporary, unfortunately, because the Constituent Assembly was not in session, it became permanent. But that is not what the Constitution of India wanted to achieve through the heading that's obvious. Therefore, the Government of India did not have any choice but to explore other options. And I think the direct method that they could have done it was under this. And therefore, I think it will not be hit by the aspect of colorable legislation because what you could have done directly is no longer available to them. So therefore, they had to explore other options is my humble answer in this topic.
Thank you, sir. That was a wonderful answer and explanation and insight into the question raised by Mr. Setia.
Thank you. Thank you.
I guess there are no further questions here. We can wait for 2 minutes more if there are any questions.
Sure.
If anybody
Sure,
likes to unmute themselves and have a discussion with sir,
it need not be questions. It can be value addition, or if anyone wants to share their opinion on the subject also, I'll be more than happy to learn something here today.
Yes. If anybody...
Good evening, sir. My name is Gautam Krishna.
Hi, Gautam.
Sir, I would like to ask you a question about it's my doubt, sir. Sir, can you
Sure.
please explain me the maintainability of Kerala filing against Union of India based on CAA under Article 131?
Correct. So I had raised it during my presentation. I'll just quickly take a minute and explain it again. So 131 states that there has to be a question of law or a question of fact flowing out of a legal right of a state. Now, so there are two conflicting Supreme Court opinions on this. The first judgment states that central law cannot be challenged. The latter judgment in 2012 states that central laws can be challenged. Now, since both the judgments are of a strength of two judges, there's a doubt as to which will prevail. Therefore, the question of law has now been referred to a larger bench and it's under consideration. The judgment is not out. So your final answer to your question will lie only from the Supreme Court judgment. But if a literal interpretation has to be given, if the state of Kerala proves before the court that there is some legal right of them that is affected, then they will be allowed to approach under 131. Otherwise, I think the option of writ petition is always available to all state governments to challenge any law.
Sir, while challenging the provision of an act, shouldn't the objective of the act be looked into, which the Supreme Court has clearly proved it? So is it like Kerala, the state of Kerala just filing it under Article 131 for political intention?
See, that's again a very well settled principle of law. I think I can even give you a case law. Just give me a second. So this Tashi Gaming Solutions versus State of Karnataka. All right. So this case clearly mentioned that no political considerations will be considered under Article 131. No political agenda can be infused with the petition under 131. If found, I think the petition will directly be dismissed. In light of that, I think it can be a political stunt or to gain some political mileage. But I think if the court really looks into the merit, it can be allowed and it will be heard only if it proves that State of Kerala has a legal right flowing.
Okay, sir. Thank you, sir. That was
Thank you.
a detail. Thank you, sir.
Thank you, Mr. Gautam. That was a very interesting question and a discussion. The next question is from Mr. Darshan. Sir, he says, the President made a modification while revoking Article 370, Constitutional Assembly to Legislative Assembly. In the presentation you mentioned, sir, he says that whether it is right or wrong, that should be held by the Supreme Court. What if the Supreme Court holds it wrong?
Then I think whatever the president did will be held as violating the provisions of the Constitution. Article 370 and the status of Jammu and Kashmir prior to August 5th, 2019, whatever the status of that was at that particular point of time, will be restored. I think that is what will happen. Yes.
That was a on-point answer, sir. We have a next question from Ms. Amrita Mauli. First of all, she thanks for your presentation, and she asks, now despite being federal, on adapt reading there seems to be a unitary governance on the part of the center. Sir, in your opinion, are we leaning towards a cooperative federalism or competitive federalism?
Very good question. But again, with my limited knowledge on this, I would answer it in two limbs. See, there is definitely cooperative federalism, but when it matters the most, I think the center will always take a front seat. Now, why do I say there is cooperative federalism? For example, take the GST. All GST policies, they have the GST Council. The GST Council has representatives from all states because all taxes that we pay, all states have a common interest. So therefore, I think there is cooperative federalism when it concerns, in particular aspect of GST, there is cooperative federalism. However, if you look at the scheme of the Constitution, 254 states that the central law will prevail over the state if there is repugnancy. 256 states that center can give directions to the states and the states are obliged to listen to such directions. And so therefore, I think, in matters of law and control over the country's operation, I think the center holds. But when concerns policies, I think, keeping GST as an example, I think we are moving towards the society of cooperative federalism.
Thank you, sir. We have Abhishek Setia raising his hand. I would like to unmute him.
Sure.
Yes, thank you, team. And I'm sorry that I couldn't unmute myself last time because of technical error. But the question was really well taken, Mr. Chandrasekhar. Thank you for that. I just have another question. So during the course of your presentation, sir, you had spoken about conflict between two central enactments. And in the event that both are special legislatures, the latter will prevail over formal.
No, I did not say that. I said whatever is, I think there has to be, you can finish your question and I can answer. I'm sorry.
No. Please, let's have clarity on that point, sir. Just to ensure that we're on the same page.
Yeah, so I think when I mentioned there's a conflict between two special acts, I think the object that, what interpretation facilitates both the legislations to be alive and kicking, I think that will be the view taken by the court as the first instance. When that is not possible, I think they'll resort to other mechanisms such as the latter will prevail over the former. In fact, the example that I gave, the SICA and the RDDB, SICA was for SIC companies to recover. RDDB was to recover money.
Yes.
RDDB was a latter act. But unless the SIC companies recover, they'll not be in a position to pay. Therefore, even though RDDB was a latter act, the court held that despite both being special, SICA has to be given precedents because the main objective should be for the sick companies to recover first.
Yes, in that light, sir. So now both RDDB and SICA, these are all economic legislations, economic legislations which deal with recovery and say insolvency. So coming to little further in time, considering new legislations, let's say two special legislations like the Insolvency and Bankruptcy Code, which is a code in itself, and something completely operating in a different sphere like the National Green Tribunal Act, which is functioning in the area of environment. In the event there is a conflict between these two statutes, wherein proceedings are being initiated before the NGT against any party, and say that it's a company and it is going into insolvency, there is a moratorium under Section 13 of the Insolvency and Bankruptcy Code. So both these statutes are special. Both these statutes are very important in their own spheres. And in the event there's a conflict arising now, how do you deal with that?
Very interesting question. And I would like to begin this answer by a disclaimer. I have not dealt even with one provision of IBC nor under the NGT. I would still try to take help from my
I can
SICA
also
and
add on, just because you just stated this, sir. Both these statutes have non-obstante clauses wherein they say that they will prevail over any other law for the time being in force. And
okay.
With respect to Section 13 of IBC, it declares a moratorium which says that no suit proceeding or existing proceedings are required to be at hold for 90 days, which can be extended further for 30 more days. This
Correct.
is Section 13.
Correct.
Similarly, under NGT Act, if proceedings is initiated, which could be under the set of any of the environment legislations, which is Water Conservation Act or Environmental Protection Act, so on and so forth. So this is just a brief background, but with respect to the repugnancy, it's pretty similar to SICA and RDDB, just that now the two statutes are operating in completely different spheres.
I think, Abhishek, I would still take the aid from my SICA RDDB example and answer your question. See, IBC, again, it issues a moratorium for a particular purpose. That is, completely concentration should be for the IBC proceedings. All right. So let's first decide as to what is happening with the company. Assuming there is an environmental violation that is going on under the NGT, and there is a huge loss that is imposed, penalty that is imposed, or a punishment that is imposed, or an environmental clearance is being cancelled, or building approval is being cancelled, everything so on and so forth. None of that will matter if the company is no longer in existence. Therefore, I think even in that example, proceedings under IBC should be given the priority because that has to be sorted out first. If the company is gone, then I think automatically all other proceedings against the company is infructuous, and any recovery will not be possible, any penalty will not be possible. On the other hand, if NGT is the point being is, I think IBC will still prevail in this case because unless that is figured out, any other connected issue with the company cannot be sorted.
Can I follow up to that, team?
Sure, sir.
Yes. So I have two follow-ups to this point. One is, I feel that this interpretation is very dangerous because tomorrow any company can violate the regulations, environment regulations, and to just apply for insolvency, wherein they can, after application of insolvency proceedings, after 120 or 150 days, come back and say that the company is going to become a going concern after appointment of the insolvency resolution professional, and they can just revive with a new management. That way they can find an escape route through this tunnel. And two, how can we say that IBC will prevail over the former just because of the fact that this deals only with recovery? So let us say Environmental Protection Act or any of the environmental laws do not particularly deal only with recovery. They also impose penalty in the nature that it could also lead to imprisonment. So under such a circumstance, and IBC deals with that particular company, which may or may not be a going concern. However, all the environmental laws are in rem. So any impact by the decision there will be in rem. So how can we say that the IBC will prevail over the other?
Good question, Abhishek. So with respect to your first part, I'm pretty sure, Abhishek, since speaking from a complete lack of knowledge on this subject, I'm pretty sure that if there are frivolous petitions that are filed only to evade the legal angle, I'm pretty sure the courts will have a mechanism to hold that frivolous petitions cannot be filed just to escape proceedings on another forum. That's my point one. Two, I think any writ can help in that case. Two is I totally understand. That's why I said it's not only with respect to recovery, but there are other connected angles regarding imprisonment, etc., like you mentioned. But again, my only concern is if there has to be a company against which proceedings has to be initiated, there has to be a company in the first place. And I think keeping that in mind, that is the reason for my explanation on why IBC will prevail over the NGT. But I'm pretty sure I've your points are well taken, and there is of course merit in what you say.
Yes, thank you, sir.
Thank you.
Thank you, Mr. Setia. That was an interesting discussion we had. Mr. Gautam has one more question.
Yes, please.
Mr. Gautam, can you please unmute yourself?
Yes, sir. So my doubt is about Article 226. It's about the state of Kerala and union, sir. So Article 246, Article 246 contains the list of subject matters of union, state, and concurrent list. So the citizenship being a matter of the central government, so the state of Kerala passing a resolution mentions that they won't pass or implement it in the state, which is a violation of their own rules. That is Kerala Legislative Assembly Act, Rule 119, Clause D, and beyond their subject, ambit of subject. So can that be regarded as a breakdown of cooperative federalism, sir?
Yeah, I would say so, because not entirely aligning with that particular phrase that you used, but I think it is a breach of constitutional obligation on the side of state of Kerala. That's what I would like to say, because Article 256 states that there is an obligation on the state to implement the laws passed by the parliament until the court holds it unconstitutional. So therefore, there exists an obligation on every state under 256 to implement. So if they are not doing it, I don't think the resolutions are binding on the union or any other state or even that particular state. And that is a clear breach of 256 of their constitutional obligation to implement. I think that is the approach that I think we all should take.
Thank you, sir. Got it.
Thank you.
That was a technical approach you pointed out, sir. If anybody has any question, or if they would like to raise their hand or have a discussion on the subject or constitution, they can feel free to raise their hand. I think
it's all. I think it's all exhausted.
Yes, sir. But yes, we had a very fruitful
I believe
session.
the presentation was so good that it's leaving no room for other questions.
Thank you, Setia, for the kind words. Thank you.
Yes, you're right, Mr. Abhishek. The presentation was very clear and when filled with a lot of cases and illustrations. I think we can conclude here. Yes, there is one more question which has popped out. Mr. Shivashankar wants to ask a question. He's asking, can you explain about state and center Indian constitutional law, sir?
I did that for 40 minutes.
Yes.
I don't quite understand. Can you unmute Shivashankar so that I can hear it directly from him as to what he is expecting from me?
Yes, sure, sir. Can technical team unmute Mr. Shivashankar?
Yes, I'll do that. I believe he's not in a position where he can unmute himself.
So, is he asking for the notes that I made for this webinar to be shared, or I'm not able to quite understand what he's asking. I'm sorry.
Mr. Shivashankar, can you please unmute yourself and so that we can have a more clear discussion on this, on the question you raised. I think he's not able to. He's not
Yeah,
able to get us.
I can send all the notes and citations that I mentioned to one of your organizers. I think if you can share it with the others. No problem.
Yes, that would be great and helpful, sir.
Sure.
So we would like to. Okay, there's one more question.
Sure.
Ms. Amrita Mowli says the scope of federalism is different in different nations, whether it be Federation of States in the US or federalism in India. She's asking whether it's the asymmetric scope on an international platform. What's the asymmetric scope?
Yeah, I don't understand the question. Can you unmute her? I can hear it directly from her.
Yeah, on it, sir.
Hi, can you hear me?
Yeah, please.
Yeah, so my question here is the fact that when we talk about the Federation of States in the US, then it is dealt differently from being the scope of federalism in India. So if maybe you could tell us more about how federalism or how the power between the state and the union is interpreted differently in maybe a more wider scope of angle, which is on the international platform.
Okay, I mean, my knowledge extends only to the US. I think that's why that's a complete federation. This is quasi-federal, where the state still holds control and takes the front seat. And I think that's the only area of difference where US and India has. So US has a lot of states that has their own prerogative to do literally everything on par with the federal government. Headed by the president. I think on that ground, the effective check over the states is way lesser when compared to India. I think that's what makes the classic difference between India and the US. The check over the operation of the states is, I think, the distinction factor between US and India.
Yes, that was a distinction there.
Yeah.
Do we have any more questions?
I think it'll be better to just wait for a minute.
Yes.
Thank you.
We have a question
Sure.
from our junior, Mr. Adesh.
Sure.
Whether the government can split the state into two union territories, he's asking.
I think. Wait, let me. I think any demarcation can be done by the settled government. I think Articles 1 to 5 entirely deal with that aspect, where demarcations can be done, and I think the answer is yes.
Thank you, sir. That was a crisp answer.
Yeah.
He further asks, sir, can the government do it even if it's against the state interest?
I don't see. Again, the answer would lie where the central government is not influenced by what is the best interest of that particular state. I think if it falls within the legislative entry of the union, And if it is a competent legislature that is enacting a particular legislation, even if it involves against the interest of that particular state, if it can be traced to the powers of that legislature, I think it is a perfectly valid under law. Just like how what just like what public opinion will not matter in determining policies or influence judgments of the Supreme Court. I don't think the state's interest will matter to the parliament if it decides to pass a law if it falls within that particular legislative entries available to them.
Yes, sir. That was a crisp answer. And that is why precisely we have three different lists and stipulated subjects therein for the parliament to make laws.
Correct.
And
I think if there are no more questions, I think you can wrap it up instead of waiting.
yes, yes, sir. So first of all, I would like to thank you for taking out time from a busy schedule and having the webinar here with us today, and such a detailed presentation on the center and state relationships and the Article 370 interplay. We would always be indebted to the Law Addicts will be indebted to you for today, as well as you being the judge for our preliminary rounds for the National Moot Court competition. If there are no further questions, and if you have anything to say, you can.
No, I mean, I have such a great experience. I think I truly enjoyed. I had only one intention in mind, which is to not speak for too long, because listening span over the virtual forum is usually very less, especially when my target audience is students of law. I've been there, and I'm still, it's hardly been a year since I came from that side to this. So keeping it short and crisp was the intention. I hope you guys had a wonderful time. Once this is over, I'd like to hear how it went. Any changes and corrections that I can make, I'll be more than happy to incorporate them in my subsequent webinars, if any. And to mention about your preliminary moots, it was such a fun experience mooting. Judging. I think I recorded it on Instagram also. That I was so excited that I forgot for a second that I was a judge, and I called one of the participants as my lords. So I think that's how much of an impact it had on me. That was such a fun experience. Thank you, Law Addicts, again for this opportunity today. It was so great.
Yes, sir. We did have a wonderful session. Yes, the presentation was short and crisp, but it was on point, and it was. And I'm pretty sure if the citations you used can very well be used, and if went through the citations, it's obviously a source of knowledge for us. Thank you so much again, and indeed it's an honor to have you here. And all the best to your future webinars. And thank you so much, sir.
Thank you so much. Thank you.
Participants are requested to fill the feedback form before leaving the meeting today. And thank you everybody for being here and making this webinar a successful one. It was amazing to have you, sir. Thank you, everyone.
Thank you so much. Thank you.
Participants, do fill the feedback form before leaving the meeting, and have a good day ahead.